Majesty.
My lady, my lords, I'm not sure I've ever had a sandwich in this court which hasn't involved a degree of ripping up and starting again, but I was going to start.
Very good at it, Mr. Reid.
I was going to start with the facts, but I'm going to pile straight in and deal with power, if I may, in the light of the exchanges that have happened this morning, and in particular to try to address head-on the point that has been raised by a number of members of the court, namely whether or not this set of provisions does contain any power, particularly if one approaches it with Sims in mind, and one approaches it against a backdrop of duties of confidentiality under common law as part of the context for the legislation, whether this scheme contains any power to disclose what I will call the summary taxpayer confidential information.
By that, do you mean taxpayer identifying?
Yes, I do.
Yep.
That appears to be the sense in which it's been used. And the first point to note in relation to that is that this is an argument about power. Can that sort of information ever be disclosed under the statutory scheme? We're not dealing at this point in the analysis with how any such power might be exercised or how the exercise of any such power might legally be controlled. And it's for that reason that this first question raises an issue of statutory interpretation. We accept, and it is perhaps obvious, that prior to this Act and as part of the legislative context in which it was made, the common law had already recognised the strength and weight of taxpayer confidentiality. So I don't think either side before you disputes that as a relevant factor in the context, going to the context in which this was made. But I don't think anyone has ever suggested to you, certainly no one ever suggested in the courts below, that taxpayer confidentiality was some form of special beast in that respect, in this sense, that no one ever suggested or suggests to you that the defence of public interest disclosure that operates under the common law to forgive what would otherwise be a breach of confidence if the public interest justifies the disclosure, Lion Laboratories and all that line of case law, applies in principle or could apply in principle. And the reason for emphasising that is that once one takes both of those limbs, in other words, one takes the existence of common law confidentiality plus the existence of potential defences, you then need to put that background into the structure which is created by this legislation. And the punchline of that point is that it is entirely clear, we respectfully submit, that this legislation, including at its heart sections 18 and 19, is intended to be a complete code for disclosure of that sort of information and other information held by the revenue. That, we respectfully submit, is the proper sense in which the word confidentiality is used in the title to section 18, and that is the sense in which that concept, a code of confidentiality, is used in explanatory note paragraph 93, MS 1262, which you looked at this morning. It's designed to indicate that this is the central provision governing when and in what circumstances the revenue needs to keep information held by it confidential, and indeed those circumstances in which it is permissible to disclose that information. And one can see that, and this is the next point, and it's an important point about the structure of section 18. If you just go back to section 18, MS 1250 if you're on the electronic, but it's behind tab 1 of the legislation, little clip of legislation.
Except we don't seem to have that online.
You don't have that one?
I have it now online.
Oh, you do? Yeah.
Yes.
Right.
And I can email it to everyone.
Was it not emailed to me too?
No, it was given to me in a pen drive. Actually, if we could have the pen drive back, that would probably be the easiest way of
Much
letting
the
it.
easiest, yes.
Yeah. I was under strict instruction to return it. Being very biddable, I did.
Well, I find it totally astonishing that the most important documents in the case, i.e.
Right.
the relevant legislation, was
Right.
not included to begin with. I mean, this is not the way to prepare a case. Carry on, Mr. Eady. I can listen and do this at the same time.
I'm grateful, my lady. I was drawing attention to section 18, and in particular the structural aspect of it. You will note immediately that subsection 1 is the one that provides the preclusion. The general rule may not disclose information which is held by the revenue in connection with a function of revenue and customs. So that's the general rule. And if one's focusing on taxpayer confidential information, if I can call it that, you can insert those words, if you will, for this purpose, as a subset of the information covered by 1. But then 2 creates, and deliberately creates, an exception to that. It doesn't apply to a disclosure which is made for the purposes of a function. And again, if you will, one can put after disclosure to a disclosure brackets of information otherwise covered by sub 1.
So what's your case? That in applying this, we apply a combination or one or other of the common law tests of public interest, disclosure, and or Article 8 asks whether the disclosure is for a legitimate aim, well, that's the purposes of a function, but whether it's also proportionate.
My Lord, my case is that you should apply the natural meaning of the language used in the legislation. The point that I'm on at the moment is simply a point that says you don't have power applying something like Sims, because
that's what I was.
my case is that what that section does is to allow a specific type of disclosure as long as it is for the purposes of a function. That involves elements of judgment. Certainly there are issues of interpretation for the court there, because it's got to be properly for the purposes of a function, but within that there are elements of evaluation, and that properly attracts the rationality standard unless the convention is in play. And of course, if the convention is in play, you don't really need Sims. The Human Rights Act Section 6 already operates, as this court has pointed out on any number of occasions, it already operates to control, in circumstances where convention rights are engaged, to control the exercise of a broadly or generally expressed power. And that is because Section 6 requires public authorities to act compatibly with convention rights. So if and to the extent that Article 8 or Article 1 of Protocol 1 are engaged, then necessity and proportionality fall in. But if one stripped out that analysis, you would still be left on the natural and ordinary meaning of this section with the structure that you have, in other words, a general preclusion, which covers, by reference presumably to the concept of information and its generality, taxpayer confidential information, but then an exception. And the exception is not, this is perhaps the next point, the exception is not premised on the basis that it cuts out a certain type of information. The control of the nature and content of the exception in 2 is done by reference to the concepts of for the purposes of a function. And that's got nothing to do with information or excluding from the exception a certain category of information. The control and the limit of the exception created in 2, as I say, is done by reference to those concepts of there being a function involved and the disclosure in question properly being for the purposes of that function. Nothing to do with information. And that, we respectfully submit, is thoroughly telling if one comes at this whether through Sims or something like Sims, with a weather eye to trying to give effect to the strength of taxpayer confidentiality existing as a matter of common law, which I think was my Lord Toulson's particular concern. And the reason I put it that way is because not merely does that not work with the structure, in other words, the idea that there is a cutout from the exception on the basis of some species of information being taxpayer confidential information, but it doesn't work with the structure of the Act more generally, to construe or interpret sub 2 as if it were cutting out that particularly sensitive type of information. And it doesn't work that way at all, because one can see that that type of information, taxpayer identifying information or confidential information, I use the phrases interchangeably, you can see that when Parliament has wanted to limit one of the operative provisions in that way and by reference to that idea, in other words, that type of information, it specifically said so. Look at the nature and structure of the criminal offence created by Section 19. It does not say in 19, if you disclose in violation of Section 18.1, you commit a criminal offence. Rather, it is limited to information relating to a person, and so it's specifically targeting the sort of information which has been the subject of the Sims debate or the taxpayer confidentiality debate. And what that suggests, when one drags it back for the purpose of construing whether or not 18.2 creates the power to disclose, is to indicate that when Parliament wanted to identify a particular species of information and then make provision about it, it did so in terms. And it's entirely understandable that Section 19, the criminal offence, the most serious in the hierarchy, should be limited to disclosures of that sort of information. Because obviously they're at the height of the sensitivity tree, and everyone understands that. But the significance of 19 for the purpose of this argument, as I say, is that it indicates quite plainly that if Parliament had intended to cut out from the lawful disclosure exception in 18.2 this species of information, it could and would have used precisely the language it used to define the criminal offence in 19. Just whilst we're on 19, my Lord, I think Lord Mance asked my learned friend whether 19 really was creating a criminal offence, save by reference to publicly disclosed information. It doesn't do that. If you look at 19.3a, it's premised on the idea of a reasonable belief that the disclosure was lawful or in the public domain. Does my Lord see that in 19.3a? And what that does, it might be thought, is to indicate the scope and reach of 18, at least in a roundabout way.
And the implication of that would be that the fact that information is already in the public domain doesn't take it out of Section 18.
Yes, that's true. We agree. We're all agreed about that, and I'm going to come back to the significance of that later. But you'll remember that was part of the reasoning of the Court of Appeal. If information is as broad as that, then the exception one would expect to be correspondingly broad, and that is reasoning with which we respectfully agree. But there's no dispute about the base of that. The point that I was on was a slightly different one, which was that it's also a defence, because the word or is in there, for the person reasonably to believe that the disclosure was lawful. So if, for the sake of argument, a court ultimately, at whatever level, disagrees with the judgment call made as to whether or not disclosure was proper, Mr. Hartnett or whoever can turn up and say, well, actually, I had a reasonable belief that what I was doing was lawful. You may have disagreed with me in the end, but I have that reasonable belief, so I have a defence to the criminal charge. But as I say, the significance for the purpose of this argument, which was the one about which there was much debate this morning, whether or not a subset or a species of information is cut out of 18.2, is that the language and the definition of the criminal offence is premised on identifying that sort of information and the disclosure being of that sort of information. So that's the first indication The first indication perhaps is the natural meaning of the words. If they were going to do it, they wouldn't do it in this way. Information isn't the controlling concept in 2 for the purposes of a function is. But secondly, and in any event, section 19 supports that. If they're going to use that language, if that was their intention, they'd have done exactly what they did in 19. The third and slightly more subtle point to be made, perhaps, is this. You will have seen, and my learned friend made great play of this in his case, no reference of it really orally, but that there are a series of other more specific exceptions created in the combination of 18.2b and following, b dragging in 20 and 21, which are disclosures for the purposes of particular types of public interest, which is why I asked my learned friend to read the entirety of 20 sub 2, for example. But you will see that some of those, if one simply focuses, I don't know, take your pick, focus on 18.2f or 18.2g, or the disclosure to the particular individual for the particular purpose in 20 sub 2, if you look at any of those, they are disclosures that will almost by definition be of individual information, because if it's in relation to a criminal offence, it's almost by definition going to be information relating to an individual. But the oddity that would be created if 18.2a, as it were, cut out the species of information, is that you could disclose taxpayer confidential information pursuant to the specific exceptions, which are by and large premised on supporting or assisting the functions of another public authority, but you couldn't do it for the purpose of assisting the functions of the revenue under 18.2a. And where we respectfully and rhetorically ask is the policy or legislative sense in that.
I'm not sure about that, because there are, in the areas where one public body may have information which may be relevant to the investigations of another public body, there can be all sorts of statutory complications. Re-Arrows discussed this in some detail. It's not unusual to have a situation where statutory authority A is given an explicit power to disclose information to statutory body B, but I don't see how that assists on the interpretation of 2A. If anything, it might be said to go rather the other way.
Well, my Lord, I'm not sure it can go the other way with respect, because it specifically identifies the body whose functions are being assisted in.
Well, then that comes to, of course, what we mean by functions.
It does. It comes to what you mean by functions, which I'm going to come back to. But on the more general point, I don't want to overdo it, because my Lord is entirely right. There are exactly examples of that type. In Re-Arrows has discussed them, and other cases of a similar ilk.
Exactly.
For the Bank of England's powers, for example, and the FSA and their relationship. The relationship between the two for the purposes of disclosure. But there is, I respectfully submit, at least a proper general point to be made, which is it would at the very least create an oddity if in relation to this type of information one could disclose for the purpose of assisting someone else's functions, but not the functions of the very body concerned, even though, perhaps I can add this as a writer to make it a little more palatable, even though 18.2a refers in terms to the assistance of their functions, or for the purposes of their functions. So we respectfully urge caution, not with the interpretive premise that Lord Toulson identified this morning, which I suspect will be common ground between us, namely that confidentiality and taxpayer confidentiality exists as an important thing, and that Parliament can be taken to know that, but with the inference, the proper interpretive inference to be drawn from that fact. That's the way we put it. And as I say, my point about the complete code, one gets it from the structure of the Act. We've all had a look at the legislative history, and it's fairly, I think, described as patchy. It goes back to the Declaration. You have the criminal offence that preceded this, created by Section 182 of the 1989 Act behind tab 3 of the bundle, the same bundle 1264, but that really doesn't take matters much further. It simply creates the criminal offence. So it's the equivalent of being the precursor of Section 19 rather than anything else. And the proper inference to be drawn, I respectfully submit, both from the structure internally of 18 and from the nature of the Act generally, is that this was precisely designed to do the very thing that explanatory note paragraph 93 says it's doing, to lay down a code of confidentiality for the new commissioners and their officers. In other words, what is precluded, when can you do it, listing the circumstances in which you can do it. And so we respectfully submit that there is not much to be gleaned from that, and nor, if one's on the explanatory note, do we submit that there is much to be gleaned from paragraph 95. It refers to providing for a limited number of specific circumstances where disclosure may be allowed, but that is no more than generically to describe what is obviously being done in section 18.2. It tells one nothing about the extent of the limited number of specified circumstances or specific circumstances then identified.
Just going back to your example 18.2f, the copy of the Act we've got in the bundle doesn't include section 27, and I'm just looking it up, and that's the section which makes provision for the Treasury to make regulations giving to the Inspector of Constabulary and equivalent bodies in Scotland and Northern Ireland the power to carry out inspections of what the commissioners have been up to.
For this, for the purpose of, I'm so sorry, I'm very ignorant because I haven't got it in front of me, but
Well,
for the purpose of this section,
Treasury may make regulations conferring functions on the Inspector of Constabulary, etc., etc. Regulations may make provisions similar to 54 to 56 of the Police Act, and so on, may enable a Minister of Crown or Commissioners to require an inspection to be carried out. So this is, as I understand it, correct me if I'm wrong, provision for external inspectors to inspect what the Revenue Commissioners have been doing. Now, if that's the case, A, it's perfectly understandable that the commissioners are entitled under the Act to disclose to those who are inspecting what they've been doing. But also, it's very difficult to see why that exception is needed if you're right on 2A. You may tell me I've completely misunderstood section 27. But
I don't know, we'll have to have a look at section 27, but I think a similar, if rather more general point is made by my learned friend in relation to the existence of some of the other exceptions.
also, B, C and D,
that are
who
created.
says, well, B, C and D are OTOs.
Yeah.
But at the moment, it does seem to me that your example in relation to F and 27 comes back and hits you rather than helping you.
But it can't destroy the breadth. I mean, if it's taken to its logical extreme, then the purposes of the function would have to be limited in some way to take account of that.
Anyway, if I've misunderstood section 27,
can I let you know?
Please correct.
Yes. My lords, my lady, I hope that at least that tries to grapple with the issue that was of particular concern this morning about the legislative context and the duties of taxpayer confidentiality, and in particular that structure of 18.1 sitting with 18.2. And it's fair, I think, to note that however else it's been put, my learned friend has acknowledged throughout this litigation that what he has to do is to try to find some interpretive hook for limiting, in the way that he suggests the power is to be limited as a matter of power. Yeah. He has to find some interpretive hook within the language of section 18 itself.
So just go back 1 second. Paragraph 101 of the explanatory notes would suggest my understanding of section 27 is correct.
Right.
That it's creating an inspectorial function for the commissioners.
My lord, yes. May I ponder that? I was on the point about the way the case is actually put against me.
Yeah.
I mean, it would presumably be said that disclosure to Her Majesty's inspectors of constabulary is not for the purposes of the Inland Revenue's functions, it's for the purposes of Her Majesty's inspectors of constabulary's functions in making a report, an inspection report in relation to the commissioners, so that...
Well, it may or it may not be. It may be a similar beast to the beast that one sees in F, G and following, where there would at least be scope for debate around whether or not you were promoting the purposes of HMRC directly, as it were, or whether you were promoting the purposes of some other body more directly.
Well, that's really the point I was putting. That
Yes, so you have the...
Section 27 is imposing obligations or giving the right to make regulations conferring functions on Her Majesty's Inspector of Constabulary expressly. So it's for the purposes of other persons, third parties' functions, which F is applying.
Well, my lord, that then would bring it very directly within 18.2f, where one sees something remarkably similar. And for the purpose of my argument, you will appreciate that I don't have to establish that separation. I simply have to establish either that there might be an argument or doubt about it. So
No, I got that.
legislative provision puts it beyond any real doubt in an important area.
When was duplication ever an argument in construction? Anyway, even if there were duplication.
Right. Even if there were duplication, they're not necessarily hermetically sealed, and sometimes you have a good policy reason for Parliament wanting to stick something on the statute book anyway, because it's a hot topic of public debate. But, my Lord, can I respectfully adopt that pro tem, that answer to my Lord Toulson? My Lords, I was on the point about my learned friend and his argument having at least previously recognised. I don't think he's never run a Sims-type argument. He's never run there is a category of information cut out of sub 2 because taxpayer confidentiality existed as the legislative context. What he does, we respectfully submit correctly, is to seek, at least in terms of the analysis, is to seek to identify some hook in the wording of 18.2 which will allow him to say, as he does as his argument, you can only disclose if you can link the disclosure to the collection of tax in relation to an individual or specified taxpayer. That's his case. And what he does in his case before this court is to focus, no doubt in recognition of the fact that that sort of limitation couldn't possibly be built upon the link concept, i.e. for the purposes of, and so he has to put it on the basis of function. So his case is that function, properly interpreted and understood in this legislation in that subsection, is to be understood as meaning for the purposes of a function of collecting tax in relation to an individual taxpayer. And we respectfully submit that that is not a tenable or correct, or at least correct, interpretation of this legislation. And I wanted, if I may, to make 5 points of interpretation about that. The first is that it is contrary, that interpretation of function, it is contrary to the natural meaning of the legislation. There is no wording in this legislation or in 18.2 to support a case that says that function is limited to the function of progressing a particular person's tax case. That would involve, in effect, inserting words into that legislation. And it was no doubt that, i.e. the recognition of the generality of the wording used, function, that led my Lord Toulson to start thinking about Sims and whether Sims could operate as a limiting principle to achieve that which couldn't be done by a natural interpretation of those words. But we respectfully submit that that case does involve scything out of the concept of function swathes of natural meaning.
I don't think it actually does, but perhaps I can come back to that when you've developed your other points.
My Lord, yes. Our case on the meaning of function is that it is a defined term. And the defined term is exactly consistent with about as broad as could possibly be imagined, I think is the way my Lord Toulson put it earlier on this morning. But we respectfully agree. Collection and management of revenue, section 5 as part of their initial functions, and then the ancillary powers, anything they think necessary or expedient in the connection with the exercise of their function, section 9(1)(a, and then section 55, which you've already looked at.
Section 51, you mean?
51, I'm so sorry, the last.
51 2A.
Yeah, exactly, that's the one.
But the question which prompts itself when one looks at those is this: is it not? You rightly say 51 2A says function means any power or duty including an ancillary power. The ancillary power is put in as broad terms as a drafter could conceivably do, because it doesn't have to be necessary. It's anything which is necessary or expedient in connection with, and if that isn't wide enough, or incidental or conducive to the exercise of their functions being anything which has some bearing on anything which they may have power to do, including ancillary powers. If all that is required is for an official to say, well, I think on the whole that it's expedient for something which is indirectly relevant to something which we do, and as long as that's not Wednesbury unreasonable, I can do it. Question is whether that cuts down very substantially the protection of the taxpayer under antecedent principles, and if so, whether it does so with the necessary specificity.
Yes. My Lord, I thought that was your thinking. And I think my answer to it is that one needs to be a little careful to split out two potentially rather different concepts, both of which are in play in relation to this first set of arguments around section 18. The first of them is a power argument. Is the correct interpretation of function such as to cut out, as a matter of interpretation, disclosure for any purpose which isn't collecting tax from an individual? So any more general purpose would be out on that interpretation as a matter of interpretation and therefore as a matter of power. The second aspect is, if there is power, make that assumption, how is that power to be exercised and what are the legal constraints operating upon it? And my answer at that point, and I'll come back to this is the second part of the submissions I'm going to make under section 18, but my answer to that is that rationality is the right standard, but you don't need me to tell you, see KU in other cases, that rationality is, at the very least, a flexible concept with a sliding scale depending upon the context and the importance of the right engaged. I'm not going to go down that route again. But rationality, if it's not convention rights engaged, if convention rights are engaged, it is the necessity and proportionality test that is involved in that. But that goes to exercise of power. The point I'm on at the moment is a point of interpretation. And by focusing on the breadth of those provisions, I entirely accept one of the points I think my Lord was putting to me, which is, doesn't it all come back to the function? If you've got the breadth of ancillary and all the additional breadth that ancillary brings, aren't you still back to function? Answer, yes, you are. But function itself, for relevant purposes, is defined in pretty broad terms.
I mean, that's the oddity. You say, indeed, it's defined in exceedingly broad terms. I mean, one could challenge whether it would be possible to find broader. But the explanatory note, to the extent we're entitled to making use of it, talks about subsection 2 providing for a limited number of specific circumstances.
So
you say it's nothing of the kind. You say it provides an extremely broad extension in a very wide range of circumstances.
I still say it's a limited number of specific circumstances. It's the circumstances identified in section 18. It may be that 18(2)A allows the commissioners to disclose information which goes beyond being driven by the purposes of collecting tax for from an individual, but it is still a limited number of specific circumstances because it sits in the range of 18(2) with all the other specific areas identified.
Well, it's a limited number, some of which are very specific, and one of which, at least on your case, is very unspecific.
It's still a specific circumstance when set alongside the other specific circumstances. It just happens to be a broad one.
Unhelpfully illustrated by the example given in paragraph 96, which addresses paragraph A and takes an example of a very narrow and obvious kind.
By way of example,
Yeah.
but not by way of definition or exclusion.
That's the tiny tail of the animal.
Well, we're construing the statute. I've got in my notebook point number 1 of 5.
Point number 1 is natural meaning.
Yes. Are we going to have the rest?
I'm very happy to give you the rest, as long as my Lord Toulson feels he's done enough to me on that point. Natural meaning is
You've done natural meaning.
You've done natural meaning.
Yep.
Secondly, structure. Again, I can take that very shortly because I've made the point already in relation to the earlier set of arguments. That militates strongly against the narrow view in my submission. There's a prohibition in 1 which is broadly expressed. Bear in mind that my learned friend focuses on the word function. But the prohibition, you will have noted in 18.1, only applies to information held in connection with a, quote, function. So if he is right, and assuming that function means the same thing in 18.1 and 18.2, it would be pretty peculiar if it didn't, given they used exactly the same word. But if he is right, that prohibition would not apply to information that is not in connection with collection of tax from a specific taxpayer. Information which is held by the revenue in connection with a function. He says function is limited to the collection of tax from a specific taxpayer. But if that is so, as long only as the word function, the identical word, means the same thing in 18.1 and 18.2, the complaint collapses because it isn't even within the prohibition. We respectfully submit it is within the prohibition. But on my learned friend's case on the meaning of function, the more general information, i.e. non-taxpayer information, wouldn't even fall within the prohibition. And that would be, we respectfully submit, very surprising indeed, and indeed directly contrary to the case that he advances. We wouldn't have to bring ourselves within an exception because we're not even within the prohibition. And you can't get away from that by fudging the words in for the purposes of into the concept. He focuses correctly, at least analytically, on the concept of function, but it must mean the same in 1 and 2. And if one breaks down the various bits and pieces within 18.1 and 18.2, it might be thought to be helpful to break the concepts down into the activity that is governed, the link, and then the thing that is served. So if one looks at 1, the activity that is governed principally is the holding, information which is held by the revenue, and then the link is in connection with, contrast for the purposes of, but no one, I think, seeks to build much on that, and then function, which is identical. And all that recognises, in order to make sense of how the two hang together, is that the activity of holding allows the revenue to hold a whole bunch of information as long only as it's in connection with a function. That's got to be to do with something that they do, I think, as Lord Mance put it. We respectfully agree. But then when you get to disclosure, it's actually got to serve the function. It's got to promote a function. But none of that touches my learned friend's argument, which effectively says that the concept of function as a matter of interpretation is limited. to collection of tax from a specific individual, but that just makes no sense at all, because it would mean that the general information, the more general information, wouldn't even be covered by the prohibition.
Well, to what extent do you say that the general information is covered by the prohibition? I've just been reading the Commissioner's annual report, which is full of facts and figures about how they have conducted their functions, with a lot of very specific figures, but absolutely no identifying information. So are you saying that that is covered by the prohibition?
Yes.
But it is a function to report on your activities? So
Yes.
it's a complete...
That's exactly what I'm saying.
Right.
So it's a very broad prohibition, and deliberately, but a correspondingly broad exception. That, my lady, is exactly how we put it. And no one, I think, has ever suggested that information in sub 1 would not include identifying information. But that's exactly the conception. It provides the complete code. You can only disclose, you can hold the information for a whole range of purposes, some of which may not be currently active use purposes, if that makes sense. But when you come to disclosure, it's got to be for the purposes of a function. If you're interpreting this, that's the way the two hang together. They're both correspondingly broad. And that same point about the breadth of 18.1 is the third of the points that we make. And it draws the contrast between 18.1 and 19. 19.1, as I've already indicated, is identity specific. But information, the concept of information, we agree with my learned friend. The concept of information which is common to 18.1 and 19.3b.
I see looking at the report on page 3, it contains the statement, "Our work is challenging, but by winning the leading case against Eclipse 35 at the Court of Appeal, we protected about £635 million in tax and sent out a strong warning against involvement in avoidance schemes." That's from a lady in the solicitor's office. So, I mean, you would say that is what? In connection with a function of the revenue and made for the purposes of a function.
Exactly so. But whatever else you do not draw the distinction. It's completely incoherent to draw the distinction on the basis of the word function.
Yeah.
It means the same thing.
Yeah.
But the point I was on for the moment was this point about information, going to my lady's point about the
Yes.
breadth of one.
So I was just catching up.
Yes, no, I'm sorry, madam. Thank you for the point. But the 19.3b point has already been made for me by my learned friend, and we agree. Because it posits the idea that you have to create a defence of reasonable belief that the information is in the public domain, because otherwise it risks being caught by the concept of information, brackets the same word, in 18.1. So 18.1 includes all information, including information which might be in the public domain already. The controlling concept of 18.1 is simply in connection with a function. But that doesn't assist my learned friend. It assists our argument for the reason correctly given by the Court of Appeal at paragraphs 25 and 29. Namely, if 18.1 is as broad, I think they put it on the basis of a concession by me. I think I've made it as a submission, but a concession will do. If it's as broad as I submitted it to be, then one would expect the concept of permitted disclosure in 18.2a1 to be correspondingly broad, because it's got to cover all of those matters. The fourth point is that if one tests the rival interpretations, and thus the presumed legislative purpose, by reference to what would and wouldn't be covered on the rival interpretations, we respectfully submit that, again, the Court of Appeal were entirely correct to say that the public would find it very surprising. I think they use the concept of a reasonable person. They would find it very surprising if certain types of disclosure that, on my learned friend's interpretation, would be precluded were not actually permitted. And bear in mind, his case's function is limited. It's only if it's collection of tax in the individual case. Well, of course, need me to tell you that the revenue's functions can include much more general matters that are not directly so related. Indeed, they have a range of functions outside tax that makes that point. But I'm not going to labour this, because the Court of Appeal, we respectfully submit, correctly made this point for us. The relevant paragraphs are particularly paragraph 29 of the Court of Appeal judgment, and also paragraph 30, where they accept the learned judge's paragraph 44. But it's all on this point. It would be very, very odd if my learned friend's case is right, because it would preclude disclosure of particular kinds that the public would find impossible to understand if the revenue were operating properly. And their punchline, with which we also respectfully agree, after the quote in paragraph 30, no good reason for the narrow reading, that's my learned friend's case, and every good reason for the wide. The fifth and final positive point we make is that on my learned friend's case, you would have an implicit, unspecified distinction of potential real difficulty, because you'd have to try and draw distinctions in relation to disclosures between the general and the specific. Now, no doubt in some cases that could easily be done, but that's not very difficult to envisage other cases in which it might be very difficult to do that. And what that does is to indicate that if Parliament was going to create that sort of difficult set of issues of distinction, it can quite clearly be expected to have said so, particularly given that it did use identifying information as a key concept in defining the criminal offence in 19. But it might also be thought to indicate a rather strange policy position, if one's looking at that as a distinction which is absolutely at the heart of 18.2a1, which is my learned friend's case, because more often than not, it might be thought, achieving what is assessed to be a general benefit for the revenue is likely to assist in relation to the specific. So it's likely to be jolly difficult to distinguish anywhere in the vast run of cases where disclosures are made in order to try and secure some more general benefit, because the whole purpose of doing that is not because they serve themselves as a general benefit, but because general benefits tend to lead to the better collection of tax in an individual and specific case. So for all of those positive reasons, we do respectfully submit that, having recognised that he has to try and find the hook, and having focused on function, and having run the case on the basis that his meaning of function is that it's limited to an individual tax collection in an individual specific case, my learned friend then has to confront the difficulties that I've just outlined, and we respectfully submit that both the learned judge and the Court of Appeal were correct to conclude that that simply didn't work as an issue of interpretation. So there is no hard-edged power distinction turning on whether the information is being sought for specific individual tax collection as opposed to more general benefits. Can I pick up some responsive points briefly, if I may, before turning to the second of the aspects that I identified in the discussion with Lord Toulson, the rationality versus necessity aspect of the Section 18 issues? But this is just simply responsive points at this stage on power and my learned friend's interpretation of the concept of function. He runs an argument, as I say, he did it very lightly orally, so it may be that it's not pursued as hard as it appeared to be in the case, but deal with it anyway. He ran the argument that the other gateway provisions become effectively pointless on our interpretation. Why are they there if 18.2a1 is so general? That's the point I'm trying to address. And the short answer we give is that they plainly do not become pointless. What is being done is to give specific examples, specific power to disclose through specific gateways, and there's nothing inconsistent with construing function so that it extends beyond collection of tax in an individual case. And as the discussion with Lord Mance indicated, I'm not sure to some extent there's a bit of a false dichotomy running through this submission that my learned friend makes, because Parliament can't be presumed to be creating logically perfect and hermetically sealed categories. Sometimes it legislates for the purpose of clarifying, sometimes it legislates because it wishes to make things expressly clear where it recognises there may be scope for argument. Serving someone else's functions is perhaps the paradigm example. But if one simply looks to see what purpose they serve, these other examples, these other gateways, even if I am right, it's not very difficult to find function, to find purpose for all of them. Some, it might be thought, look at C and D by way of example within 2, sub 2 of 18, so section 18, sub 2, sub C and D, take those as examples. Those, it might be thought, have, at least arguably, the purpose of clarifying, but they're also self-evidently limiting. So you can only disclose for the purposes of civil proceedings if it relates to a matter in respect of which the Revenue and Customs have functions, and likewise in relation to criminal matters. So there's a limiting purpose, even if we're right, to C and D. They're not purposeless. Some might be thought to be entirely obvious, but not necessarily as advancing HMRC's functions. Look at E and H. And there are others where the purpose of the disclosure would self-evidently be not, at least directly, to advance the function of HMRC, but that of another public authority. They're perhaps the greatest clutch of examples. So section 20, section 21, and then section 18(2)(f), G and I. And whether they're clarifying or additional, there's nothing inconsistent in any of them with our conception of the broader view of function. So we say first, in answer to this, in effect, they serve a purpose anyway, even if we're right. And secondly, none of them, to look at it from the perspective of advantage rather than freestanding purpose, none of them, we respectfully submit, would appear to cover the situation in which HMRC properly needs to make disclosure to the press, to the public, or even indeed to ministers, or for the purpose of taking advice from third-party analysts. So not merely do those other exceptions serve a purpose even if we're right, but they self-evidently, it might be thought, do not cover the sort of situation that I've just identified, which creates it's perhaps the same point viewed from another lens. My Lady, my Lords, the second responsive point is in relation to subsequent legislation. I'm going to take that tolerably quickly. But we've got, if you want it, it never goes into the bundles. I always have to say, if you want it, but it's JB Jamaica.
Oh, yes. I
remember
was wondering
that?
about that. That was really why I asked the question that I did earlier on.
Can I hand up copies? Would that be acceptable? I'm so sorry it comes a bit late, but If I'm allowed to say this respectfully, I'm citing it because it's recent learning from my Lord Toulson in the JB Jamaica case. But I think it would be fair to say that the Supreme Court sat on the fence on this issue, if I've analysed it correctly. That probably overstates it, but paragraph 24 is the for our purposes.
Thank you.
Thank you.
It's a bit of a different point from the present one, isn't it?
It is, because it's an amendment. It's amendment.
That was amendment. It was question, does the whole Act speak as now, or do you approach it differently?
My Lord, you're right,
they're trying to rely on separate legislation, which isn't part of the existing legislation. And I think ultimately it was simply put, well, this merely illustrates, if you want to have an illustration of the specificity which is within the drafter's skill if he wants it.
Well, if it's relied upon for illustration only, then I don't need to spend a lot of time on it. The only reason for identifying this passage is because it might be thought that the punchline that the court reaches is really remarkably similar to the sort of reasoning that feeds through the cases in relation to subsequent legislation, which is you've really got to be pretty sure that your subsequent legislation, be it amendment or separate legislation, is actually premised on and assumes a particular understanding of the other one. That's why the only reason I cited A, because it's recent, but B, because it bears in that way as a consistent line of thinking. And so if you go back, I'm not going to invite you to do it now, but if you go back to the Cape Brandy and Ennan Walsall and the line of cases my learned friend relies upon, first of all, it's got to be demonstrated that the provision is ambiguous. I'm not going to engage in the sterile debate in relation to that. But more importantly, the principle comes into play only where the later statute assumes a particular interpretation of an earlier one, or where the later legislation is plainly drafted, is I think the way Mr. Justice Leggett put it, on the basis of a particular interpretation of the earlier legislation. And we respectfully submit that none of that set of tests can apply here. There's nothing to indicate that Parliament, in passing the legislation as they did in those specific contexts, was operating on the basis of that assumption. And nor is it plainly drafted on that basis. And indeed, one needs to be a little cautious because one sees the context of both of those pieces of subsequent legislation. It might be thought to be a good illustration of Parliament seeing a pretty topical social problem, name and shame ghastly tax evaders or people who've acted dishonestly, and legislates accordingly for the purpose of punching out a social message rather than defining the extent of a pre-existing power. So we respectfully submit that the subsequent statute doesn't actually assist in the issue of interpretation. On a linked point, Pepper and Hart I think JB Jamaica also had something to say about this, paragraph 27. But normally, after you've had the desultory debate with both sides saying it's not ambiguous but in their own favour, what tends to happen is that the courts look at the extract from Hansard and say, well, you can take it one way or you can take it another way. Whatever else it doesn't clearly amount to a statement by the promoter of the bill as to the meaning of the particular provision that we're considering and the context in which we're considering it. And it might be thought that if you go back on that basis to Lord Goldsmith's statements in the presentation of the bill, its authorities, bundle 2, tab 20, 1188 to 9, so 1188 to 9. I'm not inviting you to go back now, but if you do, it might be thought that Lord Goldsmith's statement, that far from being against us, is positively supportive of the case which we advance, which is that he says it's not as open-ended as you, the probing amender, appear to be worrying about, because it is controlled by the concept of HMRC acting for the purposes of their functions.
Well, I just wonder about this. He's talking about, Lord Goldsmith was speaking in reply to an amendment laid down by his shadow. He uses the phrase controlled limited circumstances and says that the status quo is being continued, subject to the point about the prosecuting authority. I mean, that must have been, this isn't some minister making stray remarks that are being picked up here again. This must have been a prepared, I would have thought, a prepared statement. And what he said there about controlled limited circumstances is then the background to the guidance which is relied on in this case by way of legitimate expectations. That's the phrase that's picked up in the initial guidance, the general guidance paper of 4410, and then that then carried through into all the others.
Well, yes. Can I come back to the guidance, if I may? Just focusing on that, we better
But
go...
they're designed to reflect, in a way, if I can put you on the spot, Parliament's been told what the effect of the legislation is. The Revenue have issued guidance based on what Parliament has been told, explicitly. Well, for example, page 410, assurances have been given to Parliament that disclosures will take place only in controlled, limited circumstances. Now, if you here invite the court to put a wider construction on legislation, is that really a proper thing for a government department to be doing?
My Lord, the answer to that is yes. Can I explain why? It starts with the Lord Goldsmith statement, which is at 1188. And the passage that my Lord was quoting to me sits beneath, as you will have seen, 2 paragraphs below the passage which we respectfully submit is the key one. The one beginning, the noble Lord is concerned to explore the breadth of the power. Important to note for the purpose, disclosure which may be constrained by being. So he's identifying the operating constraint for present purposes as being that it's got to be for the purposes of a function of revenue and customs and not contravening a restriction. Both are important. Functions mean functions given to HMRC by Parliament, the connection and management of revenue, and those which are ancillary, such as management functions, provision of training for staff, and so on. And you've seen in the paragraph before that he's already referred to obtaining advice from ministers. So this isn't my learned friend's interpretation, which says function is limited to collecting tax from the individual taxpayer. The operative constraint that Lord Goldsmith is identifying is no more and no less than the one that we see set out in the wording of 18.2a1. And the controlled and limited circumstances, in my respectful submission, sits alongside that. The controlled and limited circumstances refer to 18.2a1 and then A2 because it's not prohibited by a restriction, and then B, C, D, E, F, G, H, I, and then sections 20 and 21. He's not there seeking to deal with or to constrain the meaning of the constraint that he's identified by reference to the express wording in the second paragraph on that page. So we respectfully submit that the reference to controlled and limited circumstances is simply a reference back to the language that is used in section 18. And then when one comes, therefore, he's not saying, and by the way, we conceive purposes of a function of a revenue and customs, of the revenue and customs as being itself as a concept limited. He's simply referring to the control and the limitation provided for on the face of the legislation and says there are gateways. of which this is one. And he defines function, as you see in the second paragraph on that page. So we do respectfully submit that that reference to controlled and limited circumstances cannot be taken as being a government statement that says this concept is to be regarded as being limited and narrow, which is, I think, the point my Lord is putting to me on the basis of that.
Yes.
And then when one comes to the guidance, which is in the core volume, sorry, it's in Appendix Part 2, behind tab D3, page 409, I think my Lord was putting to me.
Well, let's start. I was looking first of all at 409.
The general sense of it.
Effectively, what we put in a sentence, what the guidance does is import a test of necessity into 18.2. Must be necessary in order to carry out the function.
Well, my Lord, I'm going to come to that in due course, if I may, but can I just invite you, for the purpose of this point, to go to the bottom of page 413. And again, you'll have all the points that the Court of Appeal have made about the nature and effect of this sort of document. It's not drafted to be a statement of the law, it's not drafted to inform the legal concepts involved necessarily, it's designed as a precautionary guide to staff. But the use of the word necessary is explained at the bottom of 413, as you see. I say all of this goes to the exercise of the power, which I'm going to come to. It doesn't go to scope. I think the point I'm on at the moment about Hansard and what you can get out of Hansard is whether or not you can get out of Hansard some idea that this concept is to be interpreted, function, as being confined in the way my learned friend suggests.
I wonder whether actually Lord Goldsmith's right in his understanding of what is meant by the statutory language. He says that function means the function is given to HMRC by Parliament, the collection and management of revenue, well, we can all agree that, and those which are ancillary to it, such as management functions, provision of training for staff, and so on. I would have thought it's most improbable that management functions within 18.1. I mean, can't the revenue disclose, for example, whether it's operating in a building which it owns or which it has leased from a Cayman Island company without breaching on the face of it 18.1? Can't it tell the public how many members of staff it has and how it trains them? I don't believe that 18.1's really likely to be aimed at what Lord Goldsmith says in that respect. So this may not be, if I'm right, it may not be gospel, therefore.
Well, my Lord, I think you put that point to my learned friend this morning. Is there not some limit to it? Has it not got to be to do with something that they actually do by way of activity?
Yes, it's got to, I mean, the ancillary powers and duties are surely...
Or ancillary to the main function.
It's got to be ancillary to the main function. It can't just be sort of ordinary management and organisational. I would have thought, I mean, I
respectfully rather agree. I mean, I'm not sure that issue has to be determined.
No, it doesn't have to be, but it just shows that what's said in Parliament is not...
Might be a bit unreliable
perhaps we shouldn't
anyway.
question it, but...
Yes. But I'm concerned by my Lord Reid's point, because I think the suggestion being put to me is, can I properly, on behalf of the revenue, run this point, given what is said in Parliament and what is said in the guidance? And my respectful answer is that I can, for the reasons that I've given. So that's what we say about Pepper and Hart. If anything, we respectfully submit that it supports us, the Lord Goldsmith analysis. Not least because at the very start of the top of that page, you can see him referring to providing it to ministers. That isn't about individual tax collection. That can be about formulating policy in this or other areas. But so we submit that the Pepper and Hart analysis doesn't really get one very much further. Can I then turn much more briefly to the second of the aspects under section 18? So I've dealt so far with, and I hope trying to focus my oral submissions on the points that are really concerning the court on power. But there is a second question, which is whether or not, or what is the nature under this legal regime, if I'm right about power, in other words, if I'm right that one can even get into the territory because function is not limited in the way my learned friend suggests, what then is the nature of the control, the legal control over the exercise of that power? And this is really rationality versus necessity. But it is still subject to the legitimate expectation point, which is a separate issue. This is still an issue of interpretation. How is the matter to be approached? And we respectfully submit that the question for the court was correctly identified by the learned judge, namely whether or not the revenue could rationally take the view that it was appropriate to make the disclosures that he did. So whether or not rationally you fall within the boundaries that Parliament has set for the purposes of the function. If he's doing it for some other purpose, that would be wholly different. If he's doing it for something that can't properly be described as a function, that would be wholly different. But assume that he's all right on both of those, what then is the legal control? Well, the legal control, we respectfully submit, is clear. It may be a sliding scale and a context-specific analysis, but it is ultimately control of the exercise of a discretion by public law principles.
Well, does it have to be rational in the sense that it must be considered to be necessary to disclose the information?
My Lord, that isn't, as a matter of language in the statute, that isn't a prerequisite. That's why I say it's quite important to keep the analysis properly sequenced, because the first question is, what does the statute impose? And the second question, which brings one back to the relevance of the guide, and one quite understands that, is, have they bound themselves to something which goes beyond the statute?
So Mr. Hartnett could have thought to himself, well, this isn't really necessary to disclose this, but it might help. Yes. And that would be enough, would it?
My Lord, I'd prefer to put that point a slightly different way.
Well, you say the language of the Act says expedient or necessary, and therefore it doesn't have to be necessary. He thinks it's expedient, and as long as he's not completely barking and thinking it might be expedient, then it stands.
My Lord, yes, although I'm prepared to accept a greater degree of control than that, because the concept of rationality imports, and you'll bear in mind that the learned judge at paragraph 50 of his judgment was not buying the full-blown old-fashioned rationality argument, and he decided that there was a sliding scale of interest that could be engaged and a consequent flexibility in the standard. So
the background to it is that this is information which was personal to a taxpayer. So expediency, I think, has to be informed at least by the consideration that disclosure of an individual's tax affairs is not something to be undertaken lightly.
that I respectfully agree with, and that was, if I may respectfully say so, the reasoning of the learned judge. He focused on precisely that aspect. He said ultimately the test is the public law control of rationality or expediency, however you want to put it, but that is a concept which is not necessarily binary, it's sliding scale, and you take into account the interests that are engaged. That was precisely why he identified the flexibility of the standard as he did in paragraph 50 of his judgment.
Well, what if Mr. Hartnett didn't bother to think about the interests of the taxpayer at all? He just thought that this might be something that might assist in his campaign. Would that be a rational decision?
That might be more difficult, but that is not the fact. Would you go to paragraph 13 of the learned judge's judgment? MS 155, behind tab B4 in the core volume. And will you look at the finding of fact made by the learned judge in the third sentence of paragraph 13?
What was the evidence for
How rational was that belief?
Well, the evidence, the findings of fact in this case were based in the usual way in a judicial review on the statements that were produced. No one applied to cross-examine. There was no challenge to the Hartnett evidence. There was no challenge to the Franklin evidence. All of the findings of fact, I haven't gone to the facts because I thought it would be more helpful to try and address the issues of principle, but I will come to the facts.
No, but not so far as I'm concerned.
There was some debate whether they should.
Peruse Mr. Hartnett.
There was some debate as to whether it shouldn't be by private proceedings, wasn't there?
The judicial review should be.
Yes.
I don't think anyone ever suggested
No,
that it should
I
be in
see.
private.
Right.
No, private law proceedings.
Private law.
Private law proceeding. I'm
Yes.
so sorry. Yes.
Yes.
There was that particularly arose, if I recall it rightly, in the Court of Appeal,
Yes.
where they were puzzled by the idea that defamation.
But they pointed out this means that we're bound by the statements in the affidavits because they weren't
Yes.
cross-examined effectively, or
Yes.
largely bound.
And it's an important point. I'll come back to it on the facts, but it's an important point at some stage of this analysis because it said, in effect, that there was animus, that this was hostile targeting, and that is a wholly improper allegation to make if you're not cross-examining the deponent who offers reasons for doing what he did. But at the moment, and I say before I get to the legitimate expectation, this is just simply an issue of the correct approach under this legislation. And we submit expediency as the beast, but expediency informed as the learned judge held in paragraph 50 by sliding scale and the nature of the interests involved. And to some extent, if one gets there, it's quite important that that analysis is borne in mind by the court. But if you get to that point, if I can put it this way, the emotional drive that might be thought to have been pushing the court, if I've read the comments correctly this morning, towards a no power conclusion, is properly catered for, but catered for at the stage of the exercise of that power, not by adopting a strained interpretation of the existence of the power. And so far as the guidance is concerned, if I can take that, again, leaving legitimate expectation, I'll come back to it, but at this point, does the guidance inform the meaning of the legislation? That's the relevant question at this stage of the analysis, and we respectfully submit plainly not. It isn't a legitimate aid to interpretation. There are many occasions on which I wish that government guidance could affect the meaning of legislation. But what is sauce for the goose has got to be sauce for the gander. It doesn't work here. It is not a legitimate aid to the correct approach under this legislation, whatever it may say. And we respectfully recommend and agree with the comments of the Court of Appeal at paragraphs 31 to 33 on this point, where they rejected any attempt to rely upon the guidance as an aid to interpretation of the correct approach to the control of the exercise of power under this legislation. My lady, that's what I wanted to say about power and exercise of power in terms of the legal test. Can I turn briefly to the facts? You won't be surprised to hear me start with a point of general principle. The facts we submit are set out in the first instance judge's judgment. They were properly for him. They were based on two statements from Mr. Hartnett, both of which you have in the bundles. Mr. Hartnett's first statement is behind tab C3 in Appendix Part 2. Can I just give you the references without taking them up? Electronic page 316 is where the first one starts. His second one is behind electronic 391. Well, starts on page 391. I'll give you a tab in 1 second. It's C9 in Appendix Part 2. He also had statements from Ms. Dial, D-Y-A-L-L, electronic page 325 is the first page of that, and Mr. Franklin, who was the press officer who set up the meeting, electronic 337. That was the evidence by way of statements from HMRC in this litigation, this judicial review. There was none for the purpose of this litigation from the claimants. There was no challenge to the facts set out by HMRC in their statements as factual matters, and there was no application to, and there was in fact no cross-examination. And the Court of Appeal accepted in effect, and correctly we submit, that all the facts found by the learned judge were properly open to him. And there is no basis, we submit, in this court to interfere with or to seek to undermine by suggestion any of those facts. You can take the facts from the two judgments of the court below, and especially from the first instance judge's detailed analysis of the facts. And what those facts demonstrate, if I can just take a couple of topics, I hope a convenient way of dividing this up. They demonstrate first that there were three core reasons for the meeting. And it may be worth having Mr. Justice Sales's judgment to hand as I go through this analysis quickly. It's behind tab 4, B4 in the core volume. Electronic page 151 is the first page of that. And the first of the core reasons for the meeting and for what was said during it is discouragement/caution/warning to those considering taking part in these sorts of schemes.
So what paragraph was that?
That's paragraph 7.
Oh, 7, yes.
He really deals with the reasons in paragraphs 6 and 7 of his judgment on page 153 electronically. And the first of the reasons one can take out of that, he comes back to it at various other points in the judgment, but
as a matter of prosaic fact, the meeting took place because the journalists asked for it.
they did, but the revenue didn't have to go. And there was a judgment to be made around whether they should go, and if so, what purposes would be served. And the learned judge finds that that first purpose, therefore, was this general discouragement one. And you'll see the structure of the judgment. He analyses the basic purposes in 6 and 7, then analyses avoidance versus evasion in the following paragraphs, and identifies the fact that there has been specific opposition to film schemes, there's been a running problem, there's lots of risk for revenue in film schemes. And as he pointed out, the attitude of HMRC to those sorts of schemes had been one of scepticism and disapproval. That's the language he uses in paragraph 11 on page 154. That's 5 or 6 lines down. And you'll see a couple of lines further on, the finding that he makes, it's about 2/3 of the way down paragraph 11, the claimants had been aware for some time before June 2012, that's the date of the meeting, of HMRC's attitude of scepticism, and that they were investigating the validity of their schemes.
Well, they'd spoken to press about them. I think we saw 3 press cuttings.
There were 3 press cuttings that have been exhibited to the detailed grounds of resistance. But the message that HMRC wished to promulgate was effectively one of discouragement and warning that investors would indeed be asked searching questions. And you'll appreciate that the issue that is live in the tax proceedings is not about investing in avatar as an ordinary commercial investment. It is around whether or not the schemes as set up did indeed have a properly commercial purpose, or were they truly designed as tax avoidance measures. I'm sure I've inadequately summarised the essence of the dispute there, but that's the core nature of it. And if you want the underlying evidence, it's not necessary given the findings that have been made by the courts, but if you want the underlying evidence, see Hartnett 1, paras 15 and 23. That's the first message, therefore, the first reason for the meeting. The second was to head off and shape the Times, no doubt shape the Times reporting of articles, of which there had no doubt been a few at that point in time, which the Revenue regarded as being both unfair and not terribly productive from their point of view, criticising HMRC's handling and approach to avoidance, cosy deals. And you will see that that is one of the purposes of the meeting, as the learned judge found, paragraph 7. And you will see, as he records in paragraph 14, Roman 2, and as you will have seen already from the transcript, that was indeed the thrust of quite a lot of what the Times journalists were interested in. And indeed, it was in that context that Ingenious and Mr. McKenna first came to be discussed. But so the learned judge finds at 14.2 correctly that it was raised and that Mr. Hartnett was taxed at the meeting on that point. And indeed, if one wanted an example of that, you have it in Hartnett 1, para 19, and the transcript meeting, page 358 for this purpose. You may not recall there was a point at which Mr. Hartnett left the room to go and check a name or to check some details, but that was on this point. And he also emphasises, don't ask you to turn it up now, but as you will see if you go back to page 360 within the transcript of the meeting, that he was concerned to emphasise the very first time Ingenious and Mr. McKenna were mentioned, that he met him but only with lawyers, etc. And again, just to put this in context, you will bear in mind that this was a hot press topic round about then. And it was a hot press topic, particularly because, amongst others, the Public Accounts Committee were interested in the tax affairs of Goldman Sachs and et al. Various others reported in the press. And just so I don't forget it, my learned friend took you to the quotation from a letter sent by HMRC, I can't remember quite where it was now, perhaps in his case, HMRC to the Public Accounts Committee. And that quotation does, we respectfully submit, need to be read both in context, because of what the PAC were in fact after, namely specific details of specific assessments about specific taxpayers, so absolutely at the core of that information. But secondly, and as importantly, the tail end of that little quote, when you go back to it, it indicates that a thoroughly important factor in HMRC's decision not to disclose or to hold the line, as it were, against the requests that had been made by the Public Accounts Committee was that they were already governed by and overseen by the National Audit Office. There was a specific statutory regime that governed the National Audit Office's work, and it included a requirement which was operative on the NAO, the bespoke auditing body, to keep information provided to it by HMRC confidential, there being no equivalent obligation on the parliamentary subcommittee that is the PAC. But so the second of the purposes was heading off unfair criticism about cosy deals in a nutshell. Again, the learned judge made findings about that. He also made findings, this is the stuff of paragraph 6 of his judgment, about the possibility of a flow of information going the other way. In other words, from the journalists to HMRC. The possibility of journalistic research being provided to and being useful for HMRC's work, And again, Mr. Hartnett deals with that, paragraph 6 and 7 of his first statement and paragraph 15 of that statement. And as he pointed out, and as the learned judge noted, these journalists were thoroughly well informed about both tax avoidance and film schemes and lots to do with this subject matter. And they knew about details, as Mr. Hartnett pointed out at paragraph 19 of his first statement, they knew all about details of other schemes involving other sorts of film investments that might be problematic from the revenues perspective. And as the learned judge found at paragraph 6 of his judgment, the Times had already indicated they had a good deal of information about tax schemes that could be made available if the lawyers agreed. And any suggestion, if pursued, that this is really just putting up a reason after the event is a hopeless suggestion. Mr. Hartnett briefed himself in advance, see para 14 of his first statement. He went in with this aim in mind, amongst others, see para 24 of his first statement, and he raised it at the end of the meeting, as the transcript demonstrates, see page 388. But see also for that purpose, i.e. him raising it at the end, the learned judge's judgment, para 14, Roman 7, and the Court of Appeal to the same effect, para 51. So those were the purposes of the meeting. The understood basis for the meeting. And of course, I accept that if there is no power, or if there is some absolute preclusion against the revelation to anyone of taxpayer confidential information, then this part of the facts becomes of no real interest. But it is of real interest if one is in territory of considering necessity and proportionality to know that you are disclosing whatever you're disclosing for a limited purpose to a limited audience. It doesn't mean that you wouldn't, subject to other defences that might be available, breach confidence by disclosing to a single individual. But it is relevant if one is considering proportionality and necessity, particularly, for example, under the Convention. And the judgment findings in relation to that aspect, again, are pretty clear. The learned judge's judgment, paragraph 5, indicating that HMRC considered that these were publications by a national newspaper on tax, especially on tax avoidance. That was of considerable importance to HMRC and the Treasury. And it had been brought into very topical and public focus in a series of press and television pieces round about this time. See Franklin 5 and Hartnett 1, para 13. It's clear that the Times intended to publish splash articles on tax avoidance anyway, and the press office advice, see Franklin 9, was that HMRC should indeed consider engaging with these articles in this way. And as the learned judge pointed out in the second half of paragraph 13, when and if you decide, or once you decide that you're going to engage in this way, you've got to decide on what basis you're going to do that. And it's entirely obvious that you try and do that in a way which assists the objectives you're seeking to promote. See the second half of paragraph 13. And it was an off-the-record interview or discussion. And you have clear findings of fact by the courts below as to what both sides understood that to mean. Judgment paras 4 to 5 and 13, and Court of Appeal paragraph 8 and 15. And the underlying evidence positively and clearly supported that. As Mr. Hartnett put it at paragraph 8 of his first statement, but see also para 25 and his second statement at para 14, nothing said during it is quoted, published or attributed would not expect anything said in off-the-record background briefing to be published. That's Franklin, the press officer, at paragraph 8. It could not have been made clearer that that was the basis on which the meeting proceeded, and it's entirely clear, we respectfully submit, that at least at the time of the meeting, was the understanding of the journalists themselves. I'm not going to go back to it because I think the Court of Appeal quoted and referred to it, but that it was off the record is referred to consistently throughout and reinforced throughout the transcript. See, for example, pages 351, 355, 358, 360, 364, including what might be thought to be the most telling one, which is, seems a shame to waste that quote.
Would it have been proper for him to say what he did if he had believed that it would be reported?
My Lord, I think the evidence is to the effect that he would not have done so, and that was the finding of the learned judge.
We're not obliged to answer it, but I'd be interested to know what the answer is.
Well, I can I answer it in this way? I can see a much stronger case for saying if he'd used the sort of language that had been used in the context of that meeting by way of a press release, as it were, then there would have been more of an argument. I'm not going to say it would have been unlawful, but the fact is that, as the learned judge positively found in the second half of paragraph 13, he used, as he put it, as the learned judge put it, colloquial and even colourful language which he would not use in more public contexts.
Do we in fact know what his reaction was to the actual publication when it came out?
Yes, they were pretty disappointed. I'm sure we can find paragraphs in the statement to that effect, but indeed we may be able to find a passage in the judgment positively saying that, but so my learned friend's suggestion that in some way, shape or form off the record means something other than that is simply not open to him on the evidence we submit. That's the second of the areas, the basis on which the meeting took place. The third of the areas is the true extent of the disclosures in fact made at the meeting. You have the transcript between pages 349 and 390, so you can see it for yourself. But we do submit that the learned judge's summary of what was said at that meeting in paragraph 14 of his judgment is both correct and, we note, substantially undisputed. And if I can perhaps pick out just a few points from it. Firstly, the journalists were evidently a thoroughly knowledgeable group. They knew about tax avoidance, they knew about the role of film schemes, and that was fully borne out by the discussion at the meeting. See the judgment of Mr. Justice Sales at paragraph 6 and 14.1. Secondly, it was no secret that Mr. McKenna and Ingenious were not merely involved in these schemes, but were one of two lots of major players in relation to the schemes in the market, and that the journalists knew that. As the Court of Appeal noted at paragraph 8, they named him, that's the journalist named him, immediately as the other operator in the field the moment there was mention of another major operator in the field. There's nothing remotely confidential about that. Moreover, as the judge found at paragraph 11, the claimant had been aware, I've already shown you that paragraph, for some time before June 2012, that HMRC were sceptical and were investigating. And it's clear, see Annex 1 to our detailed grounds that my Lord Mance referred to, that's page 225 in the core bundle. It's clear that those details, that investigation, that scepticism was already in the public domain. The claimants appear to suggest that the Times article, this is their case for this court at paragraph 91A, was the first they'd heard that their film schemes were on HMRC's radar, but that's simply wrong on their own case. in these proceedings. In January 2012, HMRC had conveyed to the claimants its view that at least one of the partnerships wasn't trading commercially, and that's the core ground of challenge. See their own grounds, paragraph 73 at MS 203 to 204. Thirdly, Mr. McKenna's name was confirmed, that's the right way of describing it, by Mr. Hartnett, specifically in the context of the cosy deals point being put to him, including in relation to the other named individual. And he was used as an example of meeting with lawyers, if I can put it that way, so as to dish the idea that this was cosy dealing. Judgment of Mr. Justice Sales, paragraph 14, Roman 2.
Mr. Reedy, I'm getting a little bit bothered about time.
My lady, I'm going to go as quick as I can, if I may. I know I'm very conscious I've only got a couple of minutes left.
4 minutes,
Yes, I know.
yes. According to this, I'm going by this rather than that.
No, my lady, yes. He was asked about his profile, as the fourth point, and there were a series of views offered, more or less uninteresting, it might be thought, at that stage about Mr. McKenna's personality and nature. He was asked a specific question around whether or not he believed that Ingenious or Mr. McKenna were actively involved now, themselves, and said he didn't know. 361 of the transcript. There was a reference, but a bare reference, as Lord Reid has already pointed out in this hearing, to his having, that's Mr. McKenna having obtained tax relief personally, and that, it might be thought, is the high watermark, the sole true point about tax information of Mr. McKenna. But you have findings of fact about that statement. See judgment of Mr. Justice Sales, para 51, upheld by the Court of Appeal at paragraph 13. And then one has the reference to scams for scumbags. And what we say in relation to that is it wasn't for publication, it was understood to be off the record, and you have a specific finding of fact by the courts below.
Well, this was common knowledge anyway, is that the point?
No, not common knowledge anyway, but
Well, yeah, I thought this was information that was obvious in the context of Mr. McKenna's involvement in film investment schemes about which the journalists were themselves well aware. So.
yes, that's the prior point about his tax.
Sorry, what was it?
Yes, sorry, I was on scams for scumbags.
Oh, yes, sorry, yes.
And what may be said about that. But again, one has the finding of fact by the learned judge that I took you to in the second half of paragraph 13, the use of colloquial or even colourful language, and the same point being made at Court of Appeal paragraph 11. And bear in mind, as the Court of Appeal noted at paragraph 16, that phrase, which it might be thought is the most emotive, which is no doubt why my learned friend kept returning to it, was not in fact published in the articles that followed. So we respectfully submit that the conclusions that were drawn by the courts below were entirely correct. Minimal information, almost all known to or obvious to the journalists, virtually no personal information, mostly views about the HMR schemes which were pretty much common knowledge anyway, and which these people knew in any event, and they didn't need to get to the closure notice before knowing about that. And so the summary of the essence of the information disclosed given by the Court of Appeal at paragraph 22, we respectfully submit, is entirely accurate. Can I just put down a marker, which is that at the beginning of my learned friend's case, there are a series of allegations, and I use that word deliberately, which are simply that, entirely unsupported by evidence, simply assertions, unborne out by any evidence produced for the purpose of these proceedings, and in large part inaccurate. So we do respectfully submit that the appropriate course for this court is to proceed on the basis of the findings of fact in the judgments below. Take as an example, HMRC had indicated they assert in paragraph 9 of their case that it was content with the nature and structure of the partnerships. See judgment of Mr. Justice Sales, paragraph 11 for the relevant findings of fact. In fact, HMRC had been clear since 2005 that it couldn't give any general clearance for that. And so the position had not been one of acceptance. No indication, they say in paras 9 and 10, from HMRC to Ingenious that it was dissatisfied with the assistance or information given. Well, again, one simply only has to note that the tax tribunal has ordered a whole heap of further disclosure to be given by them, which bears on the issue which it is considering. HMRC, they say in paragraph 10, approved the film schemes in advance. They didn't. And indeed, a judicial review was commenced in which that allegation was made, and it failed at the permission stage. So caution, we respectfully urge. Legitimate expectation, Articles 8 and 10, I'm not going to have any time to develop that orally, but we've set it out at some considerable length in our case. And can I adhere to that? The learned judge dealt with legitimate expectation and abuse of power, both aspects to the extent that they're different. Paragraph 25 of his judgment, and then for the analysis, 60 to 61 in his judgment. And even if you get to the stage where the guidance applies, as the learned judge indicated and found, actually what is being done is to use those concepts to indicate entirely understandably that they are flexible. That's why I highlighted the bit I did at the bottom of paragraph of page 413 earlier on. And that concept of necessity does properly need to be viewed both in the context of what the guidance was actually doing and intended to do, which is a subject of some discussion in the Court of Appeal's judgment and in Mr. Justice Sales's judgment, i.e. operators' guidance to those who are operating on the ground to provide practical, workable and, in some circumstances, it might be thought precautionary approaches. But also it needs to be read fairly and in full, rather than simply looking at the headline and then saying strict necessity. That isn't what they were doing. The concept of necessity left room for evaluation and a judgment about what the best way was of securing HMRC's proper objectives.
I'm sorry, Mr. Eady, if we're going to be fair to Mr. Tomlinson.
No, well, I'm done. Can I rely in relation to the convention issues on what is said in our case? I'm sorry to have not got to those in any detail, but I hope that the oral submissions have been targeted, particularly on interpretation.
We haven't bombarded you with too many questions.
No, you haven't, mercifully.
Thank you very much indeed, Mr. Eady.
I'm grateful.
Mr. Piewski, do you have anything to add?
My Lady, my Lords, Mr. Eady devoted a considerable portion of his time to dealing with the question of the construction of Section 18(2)(a). His submissions are based on a false premise. My submission was not that the word function has some limited meaning in the context of Section 18, because, as he rightly says, the relationship between Section 18(1) and Section 18(2) would make that very problematic. My submission is that the phrase "for the purposes of a function" must be understood in the legislative context that it was, in which the Act was made, in the circumstances where, as Lord Goldsmith told the Grand Committee, controlled and limited circumstances are the only circumstances in which disclosure can be made. And bearing in mind the particular sensitivity of taxpayer-specific information. Now, that was the very point that that led the Revenue to refuse the Select Committee, the Public Accounts Committee, to refuse to give it any taxpayer-specific information. Mr. Eady, on dealing briefly with that point, didn't in fact engage with what his clients told Parliament on the subject. His clients were not saying, well, this is very sensitive information, so we can't give it. And they weren't saying, oh, well, the National Audit Office have this subject to confidentiality, so we can't give it to you because you don't have confidentiality duties. They were saying that Section 18(2)A did not permit them to disclose taxpayer-specific information to the Public Accounts Committee. Now, it's right to say, and I have to accept this, that if one looks at the plain, natural and ordinary meaning of the words, they're in the broadest possible terms. Now, there's two possibilities. The first is that Mr. Eadie is right, and Parliament intended, by enacting Section 18(2)A, to enact an extremely broad power for the revenue to disclose really anything it wished to disclose. On the face of it, is what the words suggest in the context of the definition section. But we say, in the context, that simply can't be right, because that would not be disclosure in controlled and limited circumstances, and it would make it very difficult to understand the statutory structure, which he praised in aid. But in fact, the statutory structures, there's a considerable amount of legislative ink which is spilled, trying to limit and closely define the circumstances in which disclosure can be made. If it can be made for the purposes of, if it's expedient for any function to disclose taxpayer information, none of that is needed. Now, it might be said against me, well, sometimes Parliament takes an overcautious view and legislates for things it doesn't have to legislate for. But we say that reflects the understanding of Parliament that when it came to the disclosure of taxpayer-specific information, disclosure for that purpose would only be for the very narrow purposes, which one controlled and limited purposes, which historically has been the basis of disclosure and which one finds in the guidance and in the response to the Public Accounts Committee. That's what basically I say about power. Mr. Eadie spent much less time on the other matters, but I do say that if I'm wrong about power, then all the arguments feed into the question of rationality. All the arguments about construction feed into the question of whether it was rational to make a disclosure in relation to the appellants. And Mr. Eadie spent some time on dealing with the evidence, which why Mr. Hartnett said he'd given the briefing to the journalists and so on. But what he didn't engage with was the question of why the journalists thought it necessary to give, why Mr. Hartnett thought it necessary to give the journalist his views on what Mr. McKenna did. All the purposes that he wished to achieve could have been achieved by giving a briefing where he didn't condescend to discussing the affairs of individual taxpayers, which is precisely the way he dealt with it in the Public Accounts Committee. But we say that whatever margin of judgment is extended to Mr. Hartnett, however generous that margin is, it nevertheless, he gets to the position where the court can get to the position where that is not the decision to make that disclosure is not a rational one. Can I just deal very briefly with, I was criticised, my case is criticised in relation to certain factual points. Can I just, I won't go into them in detail, but just draw the court's attention to this, that the factual points that are made in the case derive from the statement of facts and grounds. The history is set out in considerable detail, the history of dealing with the revenue. Now, I don't say, and I don't say in the case, that the revenue approved these film partnerships and said, gave them some sort of binding, made some binding concession. But what I do say, and it's set out in detail, is that Ingenious engaged with the revenue, and the revenue led them to understand that the structures that they were advancing were ones which worked and weren't regarded as improper tax avoidance. The case is based on the statement of facts and grounds, which again is evidence for the purposes of the first instance hearing, and it's not something the revenue ever sought to challenge on an evidential basis. It never put in evidence to say, no, this didn't happen, these conversations didn't happen, or you've misinterpreted them, or anything to that effect.
I thought the press cuttings showed that by June 2012, the parties were at any rate at odds as to whether these were likely to be legitimate.
Well, the press cuttings show that the revenue were investigating the matter as they perfectly entitled to do. That's of course 3 years after these have closed down. They're no longer being marketed, but the revenue have then begun an investigation. That's a. Can I just finally say, my Lord Mance raised the question of what constituted the functions and how wide or how narrow they were. The Revenue's own guidance about this is at 269. And the view that the Revenue takes is its functions include all revenue, national insurance, tax credit functions inherited from the revenue and so on and so forth. Its functions in areas such as child benefit and its functions in employing staff.
Where does it say that?
About halfway down, page 269.
How does the sentence begin?
HMRC's functions include employing our staff.
Oh, there it is, yes. Well, they may be wrong.
Well, when it comes to,
I mean, obviously they're right in one sense, but whether they're right in the statutory sense is a different matter.
when it comes to, it's perhaps just helpful to when they talk about disclosing anonymous information on page 271. When they talk about the kind of reports my lady was talking about, they publish a range of aggregate anonymised other data that does not identify individual customers for the purposes of its functions. These publications increase public understanding of confidence in the tax system, hence will increase the amount of tax collected. So that's in relation to anonymised information. I should also just say, my lady raised the question about the first-tier tribunal. The tribunal rules, like those of many other tribunals, don't provide for access to case documents. So, for example, the pleadings or the equivalent are not publicly available. The statements of case therefore can't be accessed by the public. However, once a decision has been given, either party can request that the documents be made publicly available. And the tribunal also has the power to make orders restricting disclosure, publication of specified documents and so on in a similar way to the High Court.
And the tribunal sits in private?
The tribunal sits in public.
Does it?
I think that's my turn.
Thank you. Well, thank you all very much indeed for your helpful submissions, both in writing and orally. A case which is of very considerable public importance. We will go and think about it, and let you know our answer in due course.
Sorry, thanks.